sorry. Property MBE tends to be the subject that is least favored, or people just straight up loathe them. And I don't blame them. They tend to be probably the most complicated ones. And just factually, there's a lot that happens, generally speaking. You'll have a lot of transactions that occur. So they definitely take a bit of time. They tend to be the longer fact patterns. So, when you're in the MBE, it'll take up like a full column. So every page has 2 columns on it, and the property ones will take up a full column. So you gotta kind of watch for that to not spend, far too much time on doing property problems. That being said, they're definitely workable. You can definitely do these problems and succeed on them. A lot of it is really, as I'm sure you all have found out as you're doing MBEs, a lot of it is just really practice, practice, practice. For those of you that have Adaptabar, has anybody, so I created and posted assignments on Adaptabar for those of you that have it. And for those of you that don't or didn't get access to it yet, or didn't get access to the assignments that I created because you joined, maybe you signed up later, let us know. Let Professor Matsumoto, Professor Israel, or Professor Berger know, because I've seen it working. Or those of you that I had in pre-bar this past semester, I posted a schedule on the Twin page that has a review of some critical pass flashcards. And then, so you review the critical pass, then you do the Adaptabar questions. And the people that are doing this, I'm actually seeing some pretty strong results. There's at least one student who's done every single one, and who just took a set of 100. And that student got 76% correct on a set of 100. They were all mixed and not known. So, or the person didn't have them identified as, which subject they were. So that was really promising. So I encourage you all to do those assignments. I think that it's a pretty powerful tool. So that's that. So you guys have all probably, you guys are kind of deep into bar prep a bit now. So let's start talking about some of these MBE problems. So I will walk you through the fact pattern as well. I have like multiple things up on my screen with my notes all over it, which I don't want posted. So I'm just gonna leave the camera of me up, so you guys will see me talking to you, but rather than just seeing the questions, because you all have those, I'm assuming, in front of you. When you practice this too, I do think that it's a really good idea for you guys to practice with the printed materials. There are copies of all of the questions, or at least packets of some of them, upstairs on the 13th floor outside where my office was. And outside 1356, which is where the space is open for anybody that's studying for the bar, there are some hard copies printed. Or if you need some, feel free to ask Professor Matsumoto or Professor Israel, or Professor Berger, if they're available. Because I think it's a really good idea to practice with them, not on the screen, because you got to practice how it's going to be, and you want to mark up the questions, especially with property. I think that's vitally important. So, okay, so let's, and just so you all know, I'm just getting over the flu, so I hope that I will survive this whole session tonight, but I'll do my best. So, question 1. So when you have a property question, you want to keep track of every transaction that's occurring. So oftentimes you need to sort of diagram the problems. You need to, sometimes you need to make a timeline. If you notice that there's a lease, pay attention. Is it a commercial lease? Is it a residential lease? Because then you need to know what, rights are associated with each. If you see that there's a lease, what type of a tenancy is it? If the tenancy has been assigned, then what rights go, run with the land. So you want to kind of have all of those things in mind. And the goal for everybody doing MBEs, my goal for each of you is that before you get to the answer options, you know what the answer is. So, I hear, 5 times a day, people say, well, I can always get it down to 2. And that's great, right? Like that's great. You should be able to get it down to 2. If you don't, that's, that's a little bit concerning, if you can't, but, you need to be able to get it down to 2, but the goal is to be able to predict the answer, and really just like the one correct answer should jump off the page. And if you're going through the fact patterns, and this is true for all MBEs, if you're going through the fact pattern and you can see what rule is it that they're testing, like what little concept is it, then generally speaking, the correct answer will kind of jump off the page. And it takes time to get there, but you really got to be focused as you're going through these. And not that any of you aren't, I'm sure that you are. But I just kind of like to put that out there too. Really, after you read the call of the question, after you read the fact pattern in the call, like be able to identify what is the narrow controversy, and then check to see if you got that correct. Which is why we have you do the journaling in part. So, all right, that being said, let's get into this one. So you have a chef agreed in writing to lease a restaurant from the owner of the property. So there's a lease and it's a restaurant, so it's a commercial lease. And he's agreed in writing, so satisfies the statute of frauds, and he's leasing it from the owner. So we have chef and owner. The term of the tenancy was 2 years, so we have the term, and rent was payable in monthly installments at the beginning of each month. At the end of the second year, there had been no discussions between the chef and the owner regarding renewal or termination. So as soon as I see something like this, like you see a fact like this, they don't have any discussions, then I always assume like, okay, well, what's going to happen next? So now there's going to be a termination. There's going to be either a renewal or a termination, but probably a termination, because a termination is what, somebody's probably going to get mad at that. The chef did not vacate the premises at the end of the term. Instead, she sent a check for the next month's rent to the owner. So the issue there is what is the effect of that check? So what is the effect of that check? Is it going to create a new tenancy? And then if it does, what's the term? Generally speaking, when you have someone who is a holdover tenant, and that person sends payment for the next month, then the landlord has a couple of options. You can either evict the holdover, or you can renew the lease to the same term, which would be a 2-year lease, because that's what they had previously. So the owner cashed the check after the term had expired, but informed the chef that his acceptance of the check did not mean that he was going to renew the lease or let the chef stay. So here, because he's informing the chef that this did not mean that he was going to renew the lease or let the chef stay, he is now notifying the chef that the chef is out and he's not renewing the lease at all. So essentially what he has to do is wait for the period that the check covers, and then he can pursue eviction proceedings. So that's what can happen here. So at the end of that month, the owner seeks advice on whether he can evict the chef. So there's our issue, right? And that kind of identifies the issue for us, which is exactly what we thought even before we got to that sentence. So how should the owner be advised to proceed? So now your job is to advise the owner, right? So you're told to be the lawyer here, which is good. How should the owner be advised to proceed? So let's look at these answer options here. A, the owner must give the chef a full 30 days notice before beginning eviction proceedings because a month-to-month periodic tenancy has been created. That's incorrect. That is incorrect because it misstates the law, because it misapplies the law. A month-to-month periodic tenancy was not created here because the owner specifically accepted that. So A is incorrect. B is the owner may begin eviction proceedings as soon as the additional month has expired. So with that, the owner may begin eviction proceedings, and that looks like what we thought, that as soon as that period for which rent has been paid has expired, then the owner can then start eviction proceedings. And remember, there's a rule against self-help. So really what they have to do, the owner has to use the court to go about getting possession of the property back. So the owner may not evict the chef for 11 months and must give 6 months notice before beginning eviction proceeding because a year-to-year periodic tenancy has been created. So that's incorrect. That also misapplies the law to the facts here, because this didn't even come close to creating a year-to-year periodic tenancy. But this particular answer might trip some people up because it has the correct, with the commercial lease, it kind of gets to that 6-month notice issue, which you often have for commercial leases. Or D, the owner may not evict the chef for 11 months, but need not give any notice prior to eviction because a tenancy for years, for a term of 1 year, has been created. And that's also incorrect. That also misapplies the law. Any questions on that particular one? Okay, good. Good. Thanks, guys. I like the responses. It helps. All right, so let's look at number 2. Okay. A mall leased one of its retail units to a clothing store for a period of 5 years. So again, we have a lease, and this is a commercial lease again. So we see Barbary does a good thing. One of the reasons I do suggest everybody do these Barbary questions, even though I know, Barbary doesn't use the real bar questions, but they're good because they do group things together. They group issues together a bit. So you'll see here, some questions to deal with leases and what type of a lease is it. So you get to kind of practice the same issues over and over. So you have a mall leased one of its retail units to a clothing store for a period of 5 years. The lease agreement provided that the clothing store would pay to the mall as additional rent, $1,000 a month in maintenance fees for the upkeep of the common areas in the mall. All right, so there's this additional term. The agreement also permitted assignments and subleases. So that's that fact sort of stands out to me, because usually when you see anything regarding a provision regarding assignments and subleases, it bans them, doesn't permit them. For 4 years, the clothing store timely paid all rent and maintenance fees. At the end of the 4th year, the clothing store properly assigned the lease to a discount shoe outlet. So you know that you always need to pay attention to adjectives, adverbs. So the fact that they're telling you that it was properly assigned is significant. So there's no objection to it. It's just a proper assignment. At the time it assigned the lease, the clothing store owed $3,000 in maintenance fee for the last 3 months of its occupancy. So that tells us, so at the time it assigned the lease, so before there was any assignment, the clothing store owed $3,000 in maintenance fees. So as soon as I see it, some dollar amount owed, I think that there's probably going to be a dispute. So the clothing store is liable for the $3,000 in maintenance fees, probably not the new person coming in. The shoe outlet paid its rent but did not pay any maintenance fees to the mall for the first 6 months. So then you have the shoe outlet owes $6,000 so far. The mall made reasonable efforts during the last 6 months of the term to relet the unit, but wasn't able to do so. So that says that the mall satisfied its duty to mitigate. So that's what that's telling you. So satisfies its duty to mitigate, and so now there's $12,000 in maintenance fees owed by the shoe outlet and $3,000 owed by the clothing store. So after applying the security deposit to satisfy the balance of the rent, the mall wishes to collect the unpaid maintenance fees for the last 15 months of the lease, totaling $15,000. So this is, if you just tracked who owed what, the thing that it's really testing is the clothing store liable for the additional $12,000 on this question. So you have to know, privity of estate. You have to know privity principles essentially here. And when a lease is assigned, then that lease, when the lease is assigned, the assigner and the landlord are no longer in privity of estate, but they're still in privity of contract, and the assignee is in privity of estate with the landlord. So that means that clothing store and shoe outlet are liable for the $12,000, and clothing store is liable for the $3,000. So what I'm looking for is who is liable for those fees and in what amount. So clothing store is solely liable for the $3,000, and shoe outlet and clothing store are jointly the shoe outlet. And they're jointly and severally liable for the $12,000 in fees. So they're two parties because they are still both in privity with the landlord. Any questions about that one? So that's what I'm looking for. So the correct answer is B, because that's the exact calculation I came to. A is incorrect. It misapplies it because shoe outlet is not liable for that initial $3,000. And then C and D, they're both incorrect for the same reasons. They do the they both miscalculate, but the clothing store is solely liable for. So C starts off correct, but C doesn't include the joint and several liability. It splits it evenly between the two, which is incorrect. And then D, the clothing store is solely liable for $3,000, and shoe outlet is solely liable for $12,000. That's incorrect. That's incorrect because it omits the clothing store's joint and several liability because clothing store was still in privity of contract with the mall at that time. So any questions on question number 2? No? Okay. All right, good. All right. I'm doing my best here, but you can hear I'm kind of losing my voice, so just bear with me. All right. So going on to question 3. You have a dentist rented office space in a medical building for a period of 5 years. The lease provided that the building's owner would maintain all common areas of the building, including the parking lot. So you have this special provision regarding maintenance. These are really common. So the building's owner is maintaining all common areas. 3 years into the lease, the building was sold to an investor. So the investor took subject to all of the leases. So the investor is basically saying, okay, all these tenants are mine. But he did not assume any of the original owner's obligations under it. So what's important here is for you to identify, do they have to actually expressly assume it, or do these obligations run with the land? Does it not matter? So if you're in privity of estate, then anything that runs with the land, you're still obligated to do. So, and it's just like the same rule as in the last one. So, let's see. So if there's an assignment, the building was sold to an investor. So the investor basically took over. The leases were assigned, and took subject to all of the leases, including the dentist lease, but did not assume any of the original owner's obligations under it. But there is still privity of estate between the dentist and the investor. So 5 months after the sale, a contractor hired by the original owner who was reconstructing the building's parking lot walked off the job because he had not received any progress payments from either the original owner or the investor during the past 5 months. I don't blame the guy. After notifying the original owner and the investor and receiving no response, the dentist agreed to pay the contractor $2,000 or $20,000 up front to finish the job. The dentist then withheld his rent payment of $2,000 for that month and brought an action against the original owner and the investor to recover the balance of the payment to the contractor. So is either the original owner or the investor liable to the dentist? So this is really similar in concept to the last question. So on question 3, so you have to ask, okay, well, you have to look at the privity principle. So who is in privity? So here you have the owner is in privity of contract with the dentist. So the owner is liable, and the investor is in privity of estate with the dentist. So the investor is also liable. And so that's really what, so the correct answer here is D, and that's really what it's saying is that the maintenance duties constitute an independent covenant that is part of the lease and that runs with the land. So that is what that's getting at. What that is getting at is that it's still when there is an assignment, some of those covenants that just run with the lease, run with the land, carry on to any assignee. So D is the correct answer. So A is incorrect. A just is a misstatement of law. It doesn't matter. The dentist's duty to pay rent is separate and apart. So don't worry about that. B, the original owner is liable to the dentist, but the investor is not, because the investor did not assume the original owner's obligations. This is really the red herring answer, and you want to know that that here, because there is privity of estate between the parties, and this particular duty of maintenance does run with the land, because burdens run with the land when they touch and concern. So this is a covenant that runs with the land. So here, it doesn't matter if you don't have to expressly assume if this is a covenant that runs with the land. C, the investor is liable to the dentist, but the original owner is not, because a sale by the original owner to the investor severed any privity of estate. That's incorrect. It does sever privity of estate, but it doesn't sever privity of contract. So that doesn't mean that. So it's the incorrect result. The original owner is still liable on it. So D is the correct answer. All right, question 4. All right. Excuse me. Sorry, guys. Okay. Question 4. So here, we're kind of transitioning out of doing these ones with the leases, and we're going to ones with, and so, I mean, this has a covenant, and the prior question really had a covenant also. So all of the deeds for the lots on a city block contained a restrictive covenant requiring that all houses built on the lots be set back a minimum of 50 feet from the sidewalk. So generally speaking, when you see a requirement like this, you're often going to see a conflicting requirement. So you want to pay attention to that. So see, okay, where is the conflict? Does one prevail over the other or not can both be enforced at the same time. Local zoning regulations require that all homes on the block be set back a minimum of 35 feet from the sidewalk. A man purchased, so here there is a dispute, right? So you have the restrictive covenant that requires all the houses be set back a minimum of 50 feet, and you have a zoning regulation requiring that they be set back a minimum of 35 feet. Both of these can be enforced at the same time. So these are okay. They're congruent with one another. A man purchased a lot on the block on which it would be possible to build a home with a 50-foot setback. However, the man applied to the city zoning commission for a variance, reducing the setback to 30 feet from the sidewalk. So even if that gets granted, so the zoning, even if you get a variance granted, you still do have to comply with the restrictive covenants. So he would have to get approval from both, which is probably unlikely. In his petition, the man cited the unusual shape of his land and asserted that it would cause hardship for him to build in compliance with the 35-foot setback required by the zoning regulations. The zoning commission granted the man the variance. A woman whose home was located, and then of course, like you're always going to get some rude neighbor that doesn't like that one person doesn't have to comply with the variance. So you have a woman whose home was located on the block, noticed surveyors putting up ropes 30 feet from the sidewalk on the man's lot, and she discovered that the man planned to build a home with only a 30-foot setback. The woman brings a suit to enjoin the man from building the residence with a setback of less than 50 feet. So who's going to win? So here, the issue here is that he's really, even if he gets this variance granted, he's not in compliance with the restrictive covenant. So I'm going to look for that. I know the woman's going to win, and she's going to win because he's not in compliance with the restrictive covenant. So all right, so there. So that's what I'm looking for. So who will prevail? So I know the woman will prevail, but we'll go through all of them. So A, the man, because zoning regulations take precedence over restrictive covenants as a matter of public policy. That's incorrect. Like if a zoning regulation was in effect and there was a restrictive covenant and the restrictive covenant didn't comply with the zoning regulations, then the zoning regulation would trump, but that would trump the restrictive covenant. But here it doesn't. You don't have a conflict. So A is incorrect. It misstates the law, sort of. B, the man, because equity will not impose a hardship. That's just like kind of irrelevant. That's just irrelevant. It's equity can impose a hardship. So that also misstates the law, really. C, the woman, because the man will be unjustly enriched if he's permitted to build a 30-foot setback. So nothing actually shows that the man's going to be unjustly enriched. He just doesn't have to comply with something. With a particular restrictive covenant based on the variance, but he still has to comply with the zoning. So, or I'm sorry, with the restrictive covenant. So C is incorrect because nothing in the facts suggests it. So this overstates the facts or goes beyond the facts. And then question 5. D. The woman, because the zoning variance does not affect the enforcement of a restrictive covenant, then that's our answer. So that's exactly what we thought. It's the woman's going to win, and because the variance doesn't affect the enforcement of a restrictive covenant, then that's absolutely true. So D is our correct answer. Any questions about that? Okay. Hey, you guys, I'm completely losing my voice. I don't know if you can hear it. It hurts. I might have to postpone and do just sort of like when we have our Thursday session continued. Is that going to bother immensely? I just don't know that I can keep talking because it hurts. Is that okay? Works okay. Okay. Sorry guys. I really wanted to be able to do this and not but I am just super sick. What I will do is I will post my outlines for these essays since you guys just did it. I will post my outlines for the essays that I have because that's how I plan to do this, was to post these since I can't like draw it on a board for you guys to see. So I will post these so you can see them. That way you can look at them closely, and then I will go over them on Thursday after our Thursday workshop. I'll go over the rest of these. I am so sorry. But thank you, and I will see you guys on Thursday. And feel free to reach out if you guys have any questions or anything. And Myra, I want to see more pictures. a little boy. Anyways, all right. Talk to you guys soon. Thank you so much. Sorry.